Police waited only 20 seconds before using a battering ram on the front door and forcing their way into the apartment. But how long do they need to wait before they execute a search warrant? And by the way, just because the officers obtained a search warrant doesn't mean that it's valid. You can still challenge the validity of the search warrant in court by arguing that it was not supported by probable cause. And today we're going to look at another example where an individual argues nexus. There must be a connection between the crime and the place to be searched. And before we go on, I want to thank you for watching me here on YouTube. Welcome to the Lost Hash channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to losthash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and some other items. Thanks for watching.
Quick message from Lost Hash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Hash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Hash YouTube page. That's Lawstache.
Today we're discussing a Ninth Circuit case, United States versus Chavez Miranda, and it deals with probable cause and knock and announce rule. First, let me give you some factual background. This was an operation done by the DEA agents, and they had some controlled buys, meaning they had an informant who would then purchase the narcotics from a suspected individuals, and the DEA was trying to build up a case. The informant goes and meets with Mr. Magana. This is Mr. Chavez Miranda's co-defendant, or at least the individual who will later be the co-defendant. At this point, the informant goes into Mr. Magana's apartment and purchases 1 ounce of heroin. A few weeks later, the same informant goes to Mr. Magana's apartment once again, purchases 5 ounces of heroin, and on this day, there is Mr. Chavez Miranda. He's there only shortly and leaves sort of right away when the informant comes in. A few weeks later, there was a third and fourth controlled buy. The informant goes into Magana's apartment, makes a purchase, and at this point he's introduced to Mr. Chavez Miranda, who again leaves soon thereafter. But they also set up the fourth purchase a few hours later. Now this one is the important one. When the informant calls Mr. Magana to pick up the narcotics, Mr. Magana says that he has a friend who will later deliver the narcotics, and he doesn't have them yet. The officers set up surveillance on Mr. Chavez Miranda's apartment. They see Mr. Chavez Miranda using an opener to open the gate from the complex, leave the apartment, drive up pretty close to Mr. Magana's apartment. He would stop. Another individual came up to the car, took something out of the car, a small package, and only 2 minutes later, Mr. Magana called the informant and said that he now had the drugs. Now the officers continued to surveil Mr. Chavez Miranda, who would then drive off from that meetup location, and he used what's called counter-surveillance techniques to drive back to his apartment, meaning that he was driving erratically, looking in his mirrors, changing the lanes often, not taking the path that's direct to his apartment, and so on. Now, using this information, the officers obtained a search warrant, but in fact, they obtained 2 of them, one for Mr. Magana's apartment and one for Chavez Miranda's. Now, it is Chavez Miranda who now challenges the validity of this search warrant, saying that it was not supported by probable cause. But first, let me give you some more information. Once the officers obtained the search warrant for Mr. Chavez Miranda's apartment, they went to execute it. They saw Mr. Chavez Miranda, a woman, and a child enter the apartment around 6 p.m. The officers waited about 45 minutes before executing a search warrant. They came up to the front door, they knocked on it. waited about 20-30 seconds, and then used a battering ram and forced their way into the apartment. Inside they find more narcotics, which are now the subject of this lawsuit, this criminal prosecution, and of course Mr. Chavez Miranda is trying to suppress this evidence. And by the way, before executing the search warrant, the officers knew that this was a small 800 square foot apartment. It was only 2 bedrooms, so they thought that the 20-30 seconds was reasonable before they used the battering ram. And Mr. Chavez Miranda argues that it was not reasonable. They should have waited longer. Now first, let's talk about probable cause. We know that the Fourth Amendment requires a warrant before officers conduct a search or seizure. Of course, here they had a warrant, but you can still challenge the validity of the warrant by arguing that it was not supported by probable cause. And this is exactly what is happening here. The Ninth Circuit says that we must first determine whether a search warrant for MacArthur apartment, which is Mr. Chavez Miranda's apartment, was supported by probable cause, and whether the connection between the criminal acts and Chavez Miranda justified searching that locale. We review questions of probable cause de novo, but with due weight to inferences drawn from the facts by resident judges and local law enforcement officers. We need only find that the issuing magistrate had a substantial basis for finding probable cause. In making this determination, a magistrate judge must assess the totality of circumstances and make a practical, common sense decision. Under the totality of circumstances test, otherwise innocent behavior may be indicative of criminality when viewed in context. Additionally, issuing judges may rely on the training and experience of affiant police officers. In reviewing probable cause, here's what the Ninth Circuit says. First, that there's clearly criminal activity. Mr. Chavez Miranda is seen with his co-defendant on 3 different occasions when there are controlled purchases. So clearly there's criminal activity. And second, there must be a nexus between the crime and the place to be searched. And here, the Ninth Circuit focuses on that 4th transaction. They see Mr. Chavez Miranda leave his apartment, and they knew it was his apartment because he used the clicker to open the gates. They used some mail that identified that this apartment belonged to Chavez Miranda because mail is being sent to that address with his name on it. They also saw Mr. Chavez Miranda leave his apartment, drive close to Mr. Magaña's to drop off narcotics or presumed narcotics. We have another individual who picks up these narcotics from the car. And soon thereafter, only 2 minutes later, Mr. Magaña says that he now has the narcotics. So the officers had this presumption that these must have been the narcotics that Mr. Magaña was talking about. And Mr. Chavez Miranda must have been the supplier. After the transaction, the officers also saw Mr. Chavez Miranda use counter-surveillance techniques to drive back to his apartment. So here, the Ninth Circuit says they believe that there was a reasonable connection between the crime, that is, narcotics dealings, and Mr. Chavez Miranda's apartment. The magistrate made an inference that the narcotics must have came from that particular locale, meaning Mr. Chavez's apartment. So, because there is probable cause, Mr. Chavez Miranda loses his argument, and he cannot suppress the evidence based on the validity of the warrant. Second, let's talk about the knock and announce rule, which allows an officer to break open an outer or inner door or window of a house or any part of a house or anything therein to execute a search warrant if, after notice of his authority and purpose, he's refused admittance. Officers can infer constructive refusal to admit from silence, but only after a significant amount of time. There is no established time that the police must wait. Instead, the time lapse must be reasonable considering the particular circumstances of the situation. When evaluating reasonableness, we consider such circumstances as number 1, the size and layout of the residence, number 2, the time of day, number 3, the nature of the suspected offense, Number 4, the evidence demonstrating guilt. And number 5, the officer's other observations that would support forced entry. In this case, the officers were executing a narcotics warrant. They had a good reason to believe that heroin would be found inside. Based on their observations, the officers also knew that 3 people were inside the apartment. This was a small 800 square foot apartment. And because they were executing the warrant around 7 p.m., the Ninth Circuit says this was a reasonable time when people are awake and should be available to open the door. The Ninth Circuit also spoke about the potential for violence. Earlier in the day, Mr. Magana was arrested, and he told the officers that he was afraid that Mr. Chavez Miranda would retaliate with violence. So the Ninth Circuit says that waiting 20-30 seconds under these circumstances was reasonable, and after this time, the officers could infer that they were being denied entry, and they could in fact force themselves inside. Even though Mr. Chavez Miranda did not win on either of the grounds that he raised in the Ninth Circuit, I was still thinking that this is an important case to share with you, because whether somebody wins or loses, we should know all the law, be objective about it, and so I hope you've learned something about knock and announce rule, even if you might disagree, and I hope you've learned about probable cause. If you like this video, please give it a thumbs up. If you're new to the channel, hit that subscribe button. If you're a returning viewer, thanks so much for viewing this channel, supporting me. I really appreciate it. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and other items. Thanks for watching, and I'll see you next Wednesday.